Hello, everybody. Look who was waiting. She was like literally, she was sitting right outside of the desk waiting for the greeting. Yeah. I didn't train her to do that. But I'm sure not complaining because that's cute as all get out. And look who else is joining us for the evening. Yeah, you may recognize that tail. Hi, Bandit. Ava, my goodness. My goodness. She is all excited to get her Blue Buffalo treats. Hi, baby. My goodness, I can't believe how good these things smell. No wonder she loves them. Oh, Bandit sniffing the treat box. Yeah. You want some of the treats Jerry sent you? Oh my gosh. I need more hands. Might as well be an octopus at this point with these guys. There. That's 3. That's the limit. Hello, Linda Applegate. Hello, Mortimer Duke. My goodness. Yes, I had to put this out an hour early because, you. Hi, Ava. My goodness. Yes, baby girl. Hello, Manuel. Thank you for always reminding everybody and for your sweet greetings. Hello, Nana Laura. Hello, Jerry. Hello, C-Rex. I hope you have the best dreams ever, and I'll see you when you get up to go to the bathroom. Oh, Ava. Hello, Auntie M. Hello, Eileen E. Carlin. Good to see you, honey. Thank you for being here. Hello, Charlie. Hello, Chris Van Allen. Howdy do you? Yep, the trifecta. Hello, Spider-Man. Nope. Ava's coming for you, especially if you're holding Blue Buffalo treats. Hello, Lisa Loves. Good to see you, honey. No. She really wants attention. She's an attention hound. I think when people ask me what kind of dog she is, that's what they're gonna hear. She's an attention hound. She was outside and then it started sprinkling, so I brought her back in and now she's just opened the door. I was trying to keep the door closed so that the other cats didn't come in and bother Bandit. But, what kind of a show would it be if there wasn't a little bit of kitty drama? Hi, Billy. Speaking of which, how you doing, buds? Let me get out of the way here so everybody can see you being a goof. How you doing? All you see is furry feet. Hey, Billy, what you doing? What you doing? That is too funny. I love when he does that upside down crawl under the couch. Hi, buddy. He got a bath yesterday. He rolled in poop. And I don't know why it doesn't bother them, but it doesn't bother them. It bothered me because I didn't realize that he had. It was dried on his fur. And I'm petting him and I'm like, what did you get into? You got into some dirt? And I got, it's flaking off all over my desk. And then all of a sudden, on one patch on his side, it was still wet. And I'm like, oh my God. I threw him straight in the sink. Right in the sink. He kind of fought a little bit. And then he realized he wasn't going to win. Yeah. So he got a bath. My desk got disinfected. I was not thrilled. Yeah, it was. It was. Yeah. It was something he got into outside. I just one of the joys of having a cat that's indoor outdoor. It's not like he couldn't have done it indoor at some point too. I mean, they'll find the stinkiest things to roll in. I'm lucky Ava doesn't do that. I can't high pitch scream. God forbid anybody ever break in here and like try to rob me or something. Cause like I can't scream. I just can't. I never have been able to. I would just be like, dude, get out of here. Go away. No one wants you here. Like, Ava, get him. That'd be the point where you call the pound. No, I can't do that with my babies. It'll wash off. If that was my limit, I wouldn't have a child. Yeah, my voice does carry. I have that. I have that going for me. It carries quite well. Oh, speaking of dude, um, Judge Hesselink actually hits his limit with the defendant tonight, and he's like, dude, how many times have you been in jail? It's the funniest thing. I absolutely love it. If I can figure out how to get my shorts working again, it's going to be a short. I am too fat to carry out the door. Hello, Joey Bag of Donuts. I was actually quite proud of myself at my doctor's appointment because, okay, so I'm sure most of you are familiar with prednisone, and prednisone, like, if you smell chocolate cake, you put on 5 pounds. That's just how that works. So it's just one of those medications that you gain weight and there's nothing you can do about it, but you have your choice, breathing or gaining weight. You know, I choose breathing. Well, oh, no, 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 I guess I did that wrong. Not breathing or gaining weight. I chose that I would gain weight instead of not breathing. So, anyways, they took my weight when I went to the doctors, and now I've been home. Golly, when was that? That was like September, wasn't it? I don't know. It was like a month and a half, 2 months ago, maybe, that I got hospitalized. And anyways, um, I am only 2 pounds more than when I went on the prednisone. So I have almost lost all of the prednisone weight, and I'm back on track to continue losing. I've got myself doing like 1,200 calories a day. So I like that. I like that a lot. Oh, thank you, sweetie. It's not quite that much. In the 3 years that I've been streaming, let's see, when I started streaming, I was like 297 when I started streaming, and I'm down to 269. So I was 267, and then prednisone, and now I've lost that weight, and I'm gonna continue just working on it, and you know, get there someday. Get there someday. Every time I think I'm getting there, then prednisone happens. So, oh no. Well, it is a steroid. They got roid rage. I get like insomnia and jittery, like super jittery all the time. I can't sleep on it. I go like days without sleeping, and then I just crash out for like 2 full days where I can't function. It's not a good medication to be on long term, but again, it's necessary. Hello, Squishy. I could never deprive him of that or subject you all to it. Oh, I've done it before. Never healthily, but I have done it. So this time I'm doing it healthily. But I'm sure like a lot of you have heard. I've mentioned it before, but when I was a teenager, I was anorexic. So, but I got over that. Clearly. Oh. I love when you join us, Squishy. Oh my goodness. Yeah, 32, that's pretty average. Like that's not it's not underweight. That's a good size. Oh, hi, Ava. All right, we're gonna play the cases. Ava has said so. Why did I hear Earl meow? What were you doing? What'd you do to make Earl meow? Fine. Fine.
Four 3983-ST-3. Mr. Farner, the purpose of arraignment is to tell you what you're charged with, tell you what your rights are, and then to set bond. You have, I believe, two matters setting in front of me. One is an arraignment on the original charge, and then one is a bench warrant arraignment for failure to appear. So let me deal with the original charge first. The criminal charge against you reads as follows. It says that on or about August 22nd of 2025 in Bagley Township of Otsego County, that you did commit the offense of operating while your license was suspended, revoked, or denied, in that you did operate a motor vehicle on a highway, that is Mansalona Road, while your operator's license was suspended or revoked as prohibited by Michigan compiled laws. That would normally be a low-level misdemeanor. However, because the prosecutor has filed also what's called a subsequent offense notice, there's an enhanced penalty. So let me read that to you. It says that you were previously convicted of violating the Michigan compiled laws as to driving with your license suspended on or about April 21st of 2008 in the 82nd District Court, and on or about July 6th of 2008 in the 83rd District Court, and on or about March 24th, 2015 in the 87C District Court, and on or about September 29th, 2016 in the 87A District Court, and on or about August 31st of 2020 in the 82nd District Court. Therefore, this is a higher level misdemeanor offense. It has a maximum penalty of 1 year and or $1,000 fine and vehicle immobilization. Do you understand the name of the offense that's been charged against you?
Yes, sir.
You understand the maximum possible penalty?
Yes, sir.
Right now, you have certain rights as to that charge, so let me tell you what those are. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you. You have the right to have a trial by a judge or by a jury. At a trial, you'd have the following rights: to see, hear, and question the witnesses against you, to present your own witnesses and evidence, and to get a subpoena from the court called get an order from the court called a subpoena to require those witnesses to appear and testify. You would also have the right to testify at trial, or you could remain silent and that silence would not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal automatically any error. However, if you enter a plea at any time in the future, you'd be limited to asking the court for permission to appeal. You understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
All right. Mr. Brown, have you talked to Mr. Farner about his right to an attorney?
I have, Your Honor. He does want one and he would qualify. I sent that information to Mr. Gilo's office.
All right. Mr. Farner, I'm going to approve your request for court-appointed counsel. The information is going to be sent to the attorney who administrates that procedure, and he will notify the attorney that's specifically going to represent you. Until that attorney does contact you, however, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set a pretrial conference date, which is a chance for your attorney to speak with the prosecutor to see if they can resolve the matter pretty relatively quickly. Now that we've done both of those things, I'm going to talk to the attorneys about bond, and then we'll address the bench warrant. Mr. Fortier, excuse me, Ms. Brucker, any thoughts on bond?
Just note for the court, he has 5 prior DWLSs. He has several prior OWI related offenses, as well as other types of crimes on his record, like use of meth and domestic violence. Most recently in 2021, obviously the court is aware of his record of failing to appear. So I would ask that the court set, usually on traffic offenses, we're doing PR bonds. I would ask the court to set some kind of 10% bond just to ensure that he does appear, just given with his past history.
Mr. Brown, your thoughts?
Your Honor, he's advising me he lives in Antrim County. I think maybe some of his mail might be going to Roscommon. I'm not sure if the court has an updated address or a proper address. I would just ask that the court get a good address for him as far as failing to appear or making sure that he appears so that he can be sure to get his mail.
Yeah, I never had nothing in the mail. That was kind of why I didn't know that I had to be here.
All right, well, the court used the information that was supplied by the prosecutor's office, and I'm sure that they used the information that was supplied by the police as to what your last known mailing address was, and that was an address on M18 in Roscommon.
No, they, when I was here, when they brought me here, they took my ID and they wrote the address on there. And I'm thinking, because my mail goes to a PO box in Roscommon, and on my ID, it doesn't say the PO box. It just says 2nd Street. And my grandma doesn't get mail there. That's my grandmother's address, but my mailing address is PO Box Roscommon. But I just think maybe when I was being processed, it got missed on what my actual mailing address was, because I've been calling and checking to see if I had received anything from this county, and my grandma, she's been like, no, I haven't seen nothing. So obviously if I didn't know that I needed to be here, I didn't know.
Well, the first,
And I don't
first
know where
notice-
the other failure
Well,
here comes
the
from.
first notice that we sent out was sent to South 2nd Street in Roscommon, and you didn't show up.
And
So
and
then we
that-
sent it
that-
out. Notice. Hang on, let me talk, and then you can have a chance in a minute. Then we sent a notice to North M18 in Roscommon, and you didn't show up. So then we went out and got you, apparently, or picked you up and found you some other way. So are you telling me that neither one of those addresses works for you?
Yes, sir. The one street doesn't receive mail, and I haven't lived at this address in over 3 years. Like I said, the 2nd Street is my grandmother's house, but she always uses a PO box. So that's why I didn't get the notice that it went there, or I would have been here.
What's on your driver's license, or don't you have a driver's license?
I don't have one, but I'm eligible to get it back.
So what's on your state ID card?
The 2nd Street. And I think
Okay,
that's
does
what
that
they
do-
used for my,
Well, what good does that do if they don't get mail there?
I understand. I think it's just something that it got missed.
That's not getting missed, that's ducking mail.
No,
If you know that they don't get mail there and you use that address, you're intentionally telling people, don't send me stuff.
Ducking and dodging. Mortimer Duke, what's the rest of that one?
Your Honor, I didn't give them that as a mailing address. It was just, that's what they used. They used my ID. They didn't ask for a mailing address. They just asked if that was my address. And I said, yeah, that's my address.
Dude, how many times you been in jail?
A few.
Then you know
But
exactly what they're
I'm
asking
being-
for when they say, is that your address? They want to send you something. They want to tell you when your next court date is. How are they going to do that if that address doesn't accept mail?
You're correct. Like I said, I think it was just one of the things that was lost in translation.
No,
It's
that's you,
100%
that's you.
honestly.
No, don't blame anybody else. That's all on you. They asked if that was your address and you said yes, knowing full well that they wouldn't get any mail there.
It was just one of them things that it was kind of, like I said, it was a mind slip. I mean,
Mr.
I
Farmer, I would
apologize.
advise you to just let the judge talk at this point.
okay.
Yeah, it was a mind slip, all right. Your mind slipped right out your ear and fell down the drain. You still haven't found it.
Thank you, Mr. Brown. I appreciate the blocking downfield for me. Oh, man. All right, Mr. Farner. So you want it sent to this PO box in Roscommon, is that correct?
Yes, sir.
All right, I'm going to give you the benefit of the doubt, even though I don't believe you. I'm going to cancel the bench warrant and the show cause. And now that we have your right address, we'll use that. But I got to tell you, don't do dumb things like that in the future. All right.
Yes, sir.
All right, Mr. Farner, is there anything that you would like to tell me about bond? I simply want to caution you not to make any statements about the underlying offense, as that we are recording this and it might be used against you.
No, sir. Well, just so then you did grant the PR bond?
I haven't decided what to do with bond yet. So the
Oh.
prosecutors asked for some sort of cash or bond, which would include a 10% amount, but not a PR bond. Let me add this way, Mr. Brown, is there anything else that you want to say about bond?
No, Your Honor, thank you.
Mr. Farner, is there anything else that you want to say about bond at this point?
I mean, if you guys can just give me one more shot to show up on time, I'll be here. I promise that 100%. Right now, I don't have a whole lot of outside sources. Like, I don't have a whole lot of money right now. I'm in between starting another job and finishing the other one.
What I'm doing right now, Mr. Farner, is looking through your driving history, see if there's any other information I need. All right, the driving history is, as the prosecutor indicated, full of license suspensions and revocations. In addition, in his criminal history, he's got a child support failure to pay, all of which leads me to believe that he doesn't do what he's supposed to do on a regular basis.
You said
However,
child
this is
support failure?
July 23rd, 2019, in the 34th Circuit Court, child support failing to pay pled guilty. Looks like you got 9 months in jail and fines and costs of $11,454.
It's called a record, sir. It follows you. Even if the case is all done, even if the child support's all paid, it still shows that you didn't comply back then.
That's out of Roscommon County.
Yeah, that in that case, it no longer even exists. And the child support I do pay now, I haven't missed a payment in 6 months.
All I'm saying is you've got a conviction for it on your record, which is, I do the child support enforcement in this county, and I've done it in a prior as a referee, and to have a conviction for child support non-payment is highly unusual, which tells me that you did an awful lot of not paying in the past. Even if that's not true, you got a conviction on your record for failing to pay child support, which tells me that you don't always do what you're supposed to do, which is all I said about it. So having said that, this is not a highly serious offense. It's a 1-year misdemeanor for driving license suspended, second or subsequent offense. So I'm going to set bond at $2,000, cash surety or 10%. That means you'll have to post $200 to get out. In addition to that, you'll have to appear at every court date set by the court. You must abide by any judgment of the court. You may not leave the state of Michigan without the permission of the court. You may not commit any new crime while on release. You must immediately notify the court in writing of any change of address or telephone number. And I think that'll be sufficient. I'm not going to require any other requirements. You have any questions, sir, about your bond?
Oh, sir.
All right, that'll be all for today then. Thank you.
Very much.
The court is now on the record in the matter of People versus Christopher Adam Galtier. This is file number 24-4984FH.
Kyle Travis on behalf of Mr. Gaultier. Your Honor, I was just speaking with the clerk because Mr. Gaultier has another case which is referenced in this PSI that is up, and we've already worked out a plea agreement on that. And he would like to enter the plea on that today too.
I'm not going to add another case. I know that it would benefit Mr. Gaultier, but the docket has been set for usually months in advance. And while I'm confident the clerk could gather the file, I'm confident that I could add a step. I'm not going to do that today. I'm going to instead keep the case on its general track, and we will approach that case when it's currently set for a status conference, which I would guess is next month. I understand why this
set it all as near as I can tell.
well, and I don't have a problem getting it set, but I'm not going to add it on today for a lot of reasons. But most importantly, these cases have been pending on my docket for quite some time. And as the attorneys are well aware, and Mr. Peltier, you're well aware, the only reason they're still pending is because of you. Because when I gave you a PR bond and you refused to appear for your PSI interview and your sentencing, you put yourself in this bad position. So while I totally understand that from a defense perspective, it would benefit Mr. Galtier, this is not a situation where I'm going to add to my docket on the day of the hearing. But I will have my staff immediately set Mr. Galtier's other matters to the extent they're in front of me for a status conference. Is it assigned to me? Did you confirm that?
Actually, I didn't specifically confirm that. I couldn't find it online. But
it's already been bound over.
It has been bound over, and Mr. Bear informed him that it was, but I hadn't seen it come through, and I just confirmed that it is in the circuit court. It does have a case number. But when I was trying to find it on the calendar, and I could not find it on one of your calendar dates.
Okay, well, to the extent it's in front of me, again, I'll have my staff set an available date as soon as possible for a presumptive plea or for whatever else we need to do on that case. But I'm not going to bring that up into the court docket today on this rushed basis. So does that affect how you wanted to proceed?
I don't think so, Your Honor.
All right. Does that affect how you want to proceed, Mr. Ziegler?
No, it does not.
You are Christopher Adam Galtier, correct?
Yes, sir.
Mr. Galtier, have you now had an opportunity to review the contents of the pre-sentence investigative report? And do you need any more time to review that with your attorney?
No, sir.
On behalf of the defense, and I'm just going to double check here, this is a newer matter.
This is Lenora.
And it's already been assigned to me.
Yes.
So I'm going to ask you to just put in the clerk's notes that I'm going to ask Chris to set that as my next available date for a status conference, if it's not already scheduled. In terms of the background of the PSI, then do you have corrections, additions, or deletions, Mr. Travis?
I do, Your Honor. I've been talking with Mr. Ziegler in probation on item number 12 in the criminal history. I was able to get take a look at that file this morning. It indicates that he had an unsuccessful completion of the delay. And I pulled the records from the file, and the file indicates that he did successfully complete the delay, and the conviction entered as an aggravated assault.
Is that accurate from what you can see, Mr. Ziegler?
I believe so, Your Honor. The records are not perfectly clear to me, but there is a record that Ms. Wagner is holding.
And have you been able to see that, Ms. Wagner, too?
I went and pulled some old records that we have, so I can see where the confusion is at. We do have a discharge from probation signed by Your Honor from May 30th of 18. And on our discharge, it says we did the delay of sentencing on 5/9 of 18, ordered to serve 133 days in jail, credit for 133. The charge of aggravated assault, some 50.81, be entered onto his record. However, it does say the court finds that the defendant was not successfully completed. So I think that's where maybe some of the confusion is at.
Because it said court obligations, monetary obligations remain preserved.
That doesn't say that on our, yeah, can I approach, Your Honor?
Sure, of course. And is that the probation discharge order that's sometimes different than the judgment of sentence?
Correct. And I wasn't able to access the court records in the court system because my records only go back to his 18 case, not his 16 case. So I think that's just where the confusion was at, because we put it down as unsuccessful, but yeah, put it down that he got the benefit of the delay. So
in terms of the background, then it appears that the problem was not paying the fines and costs. In a probation order, it may have suggested that it was unsuccessful because of lack of payment, but ultimately the prosecutor agreed that the terms of the plea under the delay were met. And that's why I entered the plea to the assault aggravated instead of by the other offenses.
It seems that way, Your Honor.
yes.
All right.
And the reason it matters is obviously this indicates that he's got an attempted assault by strangulation conviction. He doesn't have one prior felony. It is a misdemeanor. This is a misdemeanor PSI, so it largely isn't the biggest issue, but the difference between having a prior felony and not having a prior felony is one that I think the court should be aware of.
No, it's a significant difference. I agree. So what I'm going to suggest then in order is under narrative that all of that background is just succinctly stated, which is he successfully earned the completion of delay, had the guilty plea entered to the assault aggravated, the 1-year misdemeanor, but did not pay fines and costs, and so probation listed him as unsuccessful on probation, even though the delay was successful.
Oh,
That seems to be accurate, correct, Mr. Travis?
Yes, Your Honor.
And he doesn't have a felony conviction, so we need to update the face sheet as well, correct?
Correct.
Correct. All right, so I'll make those, and you can approach counsel. I'll make those changes. Any other corrections, additions, or deletions?
No, Your Honor.
And there are no guidelines, so turning to the prosecution or the corrections, additions, or deletions.
No, Your Honor.
Do you believe that the guidelines, that the restitution amount at $1,300 is accurate?
I do.
Do you agree that as well, Mr. Travis?
We do. We have no objection.
On behalf of the people, then your allocution.
Your Honor, the court is well aware of the history, and I think you alluded to it already when I was talking about the other file. Mr. Galtier has entered a plea to a couple of misdemeanor offenses and then subsequently failed to appear for sentencing, absconded for a period of about 8 months. And there's another file pending, will be brought before Your Honor for the court's application, possession of narcotics case. The defense counsel and I have worked out an agreement where Mr. Galtier is likely to accept the plea to use, so he has not done that yet. I think all of that background combined with the circumstances of the offense make the recommendation appropriate. I think a term of jail is certainly warranted. Probation is unlikely to be successful in this case. Defendant already has credit for 118 days. Given his absconding, given the fact that he has another file pending, given the fact that this offense involved multiple different items being stolen from the victim amounting to over $1,000, I don't believe that that is a sufficient punishment for what the defendant has done, especially in light of the fact that he has 12 prior convictions. So I would ask the court to consider imposing the entire year in county jail.
Thank you, Mr. Travis, on behalf of Mr. Galtier.
Thank you, Your Honor. Your Honor, I believe that when Mr. Galtier didn't appear, the recommendation at that time was quite likely that he would just get time served and be done. Now he finds himself having done another month plus in the jail on this. Granted, he has another case. So he's already been potentially seeing more punishment than he would have had he appeared. Part of the issue that Mr. Galtier deals with is he does have a substance abuse problem underlying in this, and not really there is, you know, at least to my understanding, Mr. Galtier and the victim in this case procuring drugs together. That's why the part of, you know, that isn't the victim's version, but why Mr. Galtier had the opportunity to do what he did, it doesn't make anything right. But I would just note that I think Chris has struggled with substance use for some time. He's obviously got this other case where there's an allegation of substance use there. I think unfortunately it causes him at certain times to make poor decisions. He's always a very appropriate and pleasant person when I interact with him, but he clearly doesn't always make the right choices. I generally deal with him when he's been incarcerated and is forced to be clean.
Oh, well, it's good to know that when he stabbed the guy, he had a smile on his face.
So I maybe see a different Chris and a different decision maker than is the one who decides not to come to court or get himself involved in these situations. But he's always a very clear-minded and reasonable and intelligent person when I interact with him. So I understand that probation is not recommended given his history, but I do think he has a lot of potential and a lot of benefit to staying away from drugs and staying on track, because he clearly is the type of individual who could be successful if he didn't have these problems. I know, as the court noted and Mr. Ziegler noted, that there probably is going to be some more punishment because of not appearing. I would ask the court to consider something, you know, in the term of 6 months or less than a year. We will likely be back and have another opportunity there. But I'm hopeful for Chris. Obviously, he's made mistakes, but I really do think he can get it together. Thank you.
Thank you. Mr. Galtier, was there anything you wanted to tell me before I impose sentence today?
I apologize for wasting the court's time. Because ultimately this is my fault, and I do have a substance abuse problem, and I am seeking help. I've had some mental issues lately because of loss of family members and stuff like that. I'm currently going through CMH and doing CHS classes. I'm doing the best with the resources I have available to me right now. And I'm hoping that I can also seek rehab if available. I didn't know if that was an option, but I am willing to take the steps I need, because when I went to rehab the first time, I went on my own accord and I completed it. I did 133 days successfully. And I just let old ways creep back in and dictate the decisions that I made, and it was wrong. I'm tired of being in front of you guys. I'm tired of being in these courtrooms. I'm 40 years old. I'm getting too old for this. I'm getting too old to wake up in a drunk tank. But like I said, it's my own fault, and I humbly and take whatever you decide. And I thank you.
Thank you, Mr. Galtier. For the first point, the time that I spend on these cases is not an annoyance to me. It's my role. It's part of the way the system gets processed. So I don't mind spending the time. What's difficult is when we have to adjourn and adjourn and adjourn when people don't show up for the court. So it's not the time that I spend, it's when I spend the time that potentially has an effect. You appear to me to be a very smart individual. You're articulate. You appear to be clean right now. That's probably a big part of that. You appear to understand the circumstances. I had that same sense when you entered your plea, because if you remember, it was me that brought up the issue of a bond, because I saw that you had already been in jail for quite some time. And even though I brought it up because I knew you were pleading guilty to misdemeanors, I could see what your attorney would be arguing ultimately is that that's enough jail already for these misdemeanors. The prosecutor cautioned me against doing that. I'm not sure if you remember that clearly or not, but his suggestion to me was that even with all of that and your ongoing child support matter that you brought up, he wanted there to be a $10,000 cash surety bond. And I overrode that. The prosecutor, it turns out, knew more than I did because his concern was well placed. I trusted you to be on a PR bond to complete the PSI process in the exact words, eerily, that I told you, is that one of the things that most affects the court's discretion is whether or not you appear.
Yes, sir.
And despite being armed with that knowledge, what the prosecutor was asking, the benefit of I was willing to give you of a PR bond on the date of a plea, which doesn't happen often. And unfortunately, when things happen like this, it leads courts to not grant that benefit to other individuals. What you did was you immediately stopped communicating. You absconded and you left. And that was 10 months ago now, 9 months ago, that you failed to appear in your sentencing hearing. Knowing full well that what I told you is if you don't appear, it just makes it easy to do what the prosecutor suggests, which is just lock you up for the amount of time that I can and keep you out of society. I don't think that reaction necessarily is fair. I think it's fair for you to suffer a consequence further than what you would have because of your actions, and especially because your absconding also led to you committing a new offense. And you'll suffer a consequence for that offense when we get there. So I'm not imposing a penalty because of that offense, but I'm certainly not ignoring the fact that I'm aware of it, and that it was while I granted you the ability to have a PR bond. We will get ultimately, when that case comes up before me, to the point of whether or not I think it's a good idea to have any type of treatment. But I need to see how that case plays out first before I consider that, even in this matter. But I'll always maintain the authority to consider treatment as an option. Because again, generally speaking, you appear to be intelligent and you know what you need to get. The problem is the carry through. And that's been the issue apparently for you for a while. It's not what your intention is. It's what happens once you get free of the constraints of the justice system. Somehow you've got to change that. And hopefully a sentence of this court can help that, but we will see. But I think for the circumstance, first and foremost, I'm going to order that you pay restitution as was requested to Dennis Tracy. You'll actually pay it to the Calcasieu County Clerk's Office. The total amount is $1,300 and it will all be dispersed to Dennis Tracy. When you're released, you must execute a wage assignment to pay restitution if you're employed and miss 2 regularly scheduled payments. I will order that you pay the crime victim assessment of $75, court costs of $325, attorney's fees of $350, and a $106 state cost. That's $53 for each misdemeanor offense. In terms of jail, your attorney's right. If you would have appeared at sentencing, you may have just gotten what you had already served. But that's not the position we're in any longer. I'm not going to act like that's the position we're in. I do think that some additional sanction is important. I told you it was going to happen if you didn't appear and you didn't appear. So I believe that a 6-month jail sentence is appropriate given these misdemeanor offenses and your actions, and that's what I will impose. 6 months in jail, credit for 118 days that you previously have served up to this date. You will also then be entitled to ask the Court of Appeals for leave to appeal. And if you want to do that, you can go through those rights with your attorney. Excuse me, you can't go through them with your attorney. They're oral appeal rights because these are misdemeanors. If you need to ask for or want to ask for leave to appeal, you need to make that request to the court within writing within the next 21 days. And if you need a court-appointed attorney to assist you with that application for leave to appeal, you need to make that request to the court within the next 14 days. You understand those rights? Yes, sir. I will have you set for a hearing in your other matter just as soon as I can possibly schedule it, and we'll address that matter and remind me, Mr. Galtier, as I'm sure you and your attorney will, about the possibility of treatment and what efforts you've done in between now and then to get into those treatment facilities. Anything else on behalf of the people?
No, Your Honor.
On behalf of defense?
No, Your Honor, thank you.
All right, good luck, Mr. Galtier.
Thank you very much.
Let's start with Tammy Pascal. Come on up. Early yesterday morning, you received a public intoxication charge. You can plead not guilty, no contest, or guilty. What do you want to do?
Yes.
I'm going to find you guilty. I'm going to assess your fines and court cost of $484. Ms. Pascal, I'm going to give you 2 days jail credit. That's $300. I'm going to release you. You have to appear here at our court no later than 2 p.m. on the first business day following your release. For a
If
hearing,
if I don't get released today, and then you finish me up, do I just have to see you tomorrow? I don't have nobody to see you tomorrow.
I can't understand what you're saying. Say it again.
Can I just finish everything so I don't have to see you
Oh,
tomorrow?
do you want to stay in jail the extra day?
Yeah.
Absolutely. Sign a voluntary remand form for the deputy.
Oh, I'm glad you understood that, Judge, because I didn't get a word of that.
Thank
Okay.
you.
Uh-huh.
Maria, I'm going to give her 334 jail credit.
No, come on over
Okay.
here.
Jonathan Martinez. Mr. Martinez, you have from September 1st, 2023, unrestrained child safety seat violation times two. Those you already pled to, they're at capious, you owe $498, you get 2 days jail credit. So your balance is $198.
Okay.
Why didn't you take care of those?
I'm a barber, so I have to pay to work, I also pay to live, and it's just I got kids as well, so it's very hard to make payments.
Yeah, you were definitely on a payment plan though. What effort did you make to come back and talk to the judge about that?
Honestly, I just completely forgot about it. I mean, life has started happening, and I didn't even know until I got here, and they're like, "Hey, your tickets." I said, "Oh."
Where are you a barber? Where's your chair?
At a major league barbershop.
Do you receive any form of government assistance?
Me, no.
Anybody in your household?
My wife receives SNAP,
Okay.
and she gets child support.
This might sound silly, but does she get it from you or does she get it from someone else?
From somebody else.
Okay, so does she receive SNAP for the children? Is she claiming you in the household?
I'm not sure. I'm not 100% sure about that.
Okay. Do you own that barber shop or do you just have a chair there?
I just have a chair there.
Perfect. Okay, I'm going to give you the $300 credit. You're still going to owe the $198. Somebody can come up and pay that for you. Otherwise, I'm remanding you on that. You have a failure to yield right of way from December 26, 2023. How do you want to handle that one? Not guilty, no contest, or guilty.
Failure to
It's
yield.
from an accident on Hillside. Looks like you had a fender bender on.
Yeah. I remember that. Yeah, I guess guilty.
Okay, I'm gonna time serve you on that one. Okay. Okay, thank you. You're free to go.
Head back to your pod for now. Probably after later.
Jason Foster. Morning, Mr. Foster.
Morning, ma'am.
Okay, so this charge is from this morning. It's called drug paraphernalia possession regarding a pipe. Fine range is $1 to $500. Court costs are $81. On that charge, do you want to plead not guilty because you want to hire an attorney, consult an attorney, or have a trial?
No, I'm just gonna go ahead and plead guilty on it.
Okay, on your guilty plea, finding court costs is $531. I'm gonna give you 1 day jail credit. So you owe $381. Here's your choice. You want me to release my hold on you so you can come downtown to court tomorrow to talk about maybe doing community service on that balance? Or do
Yes,
you want
ma'am.
to sit it out?
No, I'll come down there tomorrow.
Okay, you know where I'm located?
I don't know where you're located. I'm gonna have to get the address, you
Okay,
know.
the officer in the back will give you the address. You know where the police department is?
Not really.
You know where the Tyler Resource Center is?
Not really, but I will find it.
Well, downtown Amarillo, 3rd and Taylor. And he'll give you a map. Tomorrow, be here at 1:30, okay?
Okay.
Okay, any questions?
Okay, but the bus will know where it's at, right? If I
Yeah,
get
the
on-
bus stops really close to here. One of the main bus stations is right over here.
Okay, I'll just ask the bus driver to drop me off at your courthouse.
Well, he's gonna give you some paperwork too that tells you where to go.
Okay.
Okay, thank you. You may return to
1
your
o'clock
pot.
tomorrow, 1 o'clock
Tomorrow
tomorrow,
at 1:30.
1:30, okay, yes, ma'am.
Okay, now this was Monday.
Bye.
Mr. Foster?
Yes, ma'am.
From November 3rd, you have a possession of drug paraphernalia charge. You pled guilty on November 3rd. I think Judge Ratliff has given you some jail credit here. I'll give you 1 more day. I'm gonna apply $150 jail credit. She gave you jail credit yesterday. So your balance right now on that is $131. That's from the charge on Monday at 1:40 a.m. Tuesday, you got charged with the public intox. Yesterday, I think that there was a feeling that you were not maybe in your right mind. Maybe,
No,
yeah, but are you better today?
yeah, no, I feel kind of, I'm a bad alcoholic, see, and I'm heavy alcoholic.
I'm so sorry. Have you talked to TPC? There's some people out there that maybe could give you some direction as to some places you could go.
Well, I went to Abilene, but that wasn't what I was looking for. It was like you're underneath praying like 14 hours a day, and I was looking for a rehab, you know, not a Bible study boot
I
camp.
mean, you needed some prayer probably, but maybe maybe some other stuff too. Okay. Well, what I want to do is because you don't have any income, right?
No, we don't.
Okay. So what I think I need to do on the first charge, that first possession of drug paraphernalia, I'm going to go ahead and remand you. That means you're going to stay in jail 1 more day on that charge. Okay. So after today, you can't get out until tomorrow at 8 a.m.
Okay.
Okay. So that's because you got out and you immediately got another charge.
Yeah, I went and got.
I know. If you don't have any money, I don't understand how you can go do that.
It's easy.
Okay. Well, so then Tuesday, you got that public intoxication charge. That's the one that had us all really worried because I think you were in pretty bad shape. What do you want to do on that charge? Do you want to plead not guilty, no contest, or guilty?
I want to go ahead and pick your thing.
Okay. Now that one's $484. I'm going to give you 2 days jail credit. So that means your balance, and let me ask you this. You saw that lady up at the front who was like, let me just stay here another day. Since I remanded you on that other one, do you want to just serve this one out too, so you don't have to worry about having a warrant for not coming in?
Yes, ma'am, because it looks like I got a problem coming in for some reason, you know?
Yeah, so I'm going to give you $334 jail credit, and you're going to sign for the deputy a thing called a voluntary remand form, which means you're going to stay there 1 more day, okay? Because I'm making you stay there anyway, so you might as well say, I'll stay here on this one. Does that make sense?
Yeah, it makes sense.
Okay, and that hopefully gives you 1 more day, and then you could maybe talk to TPC and see if they can help you find a place where you can do rehab and some prayer, but rehab also, okay?
There was no AA, no NA, no nothing in this program. It was just straight on your knees, like 14, 15 hours a day.
Where'd you get that program?
They was passing out flyers and I was sitting there about half, and I got in the van and I called the number and I went to. Avenue.
Really?
Yep.
Well, ask the TPs, I know that Deputy Anderson can get you a hold of those TPC people who maybe can help find you a place that's a better fit for you.
I mean, a van pulls up and if they got flyers, they're legit. Just get in. Sounds reasonable to me. That's commitment to wanting to get clean.
Yes, ma'am.
Sure would like you to be a productive member of society.
Yeah, me too.
We need all the productive people we can get right now, right?
So when do I get out on this one?
This one, you definitely get out by tomorrow at 8 a.m. But they have to keep you till 8 a.m. or else you don't get your jail credit.
Okay.
So one more day, okay?
Yes, ma'am.
Thank you.
Thank you.
Uh-huh.
This matter yesterday, he said that he was out on a job site, he would not be in attendance today.
All right, so you don't have any objection to calling the case early?
I do not.
All right, and you are Wesley Jason Dennis.
Yes, Your Honor.
Mr. Dennis, we're here for a sentencing today. Did you have enough time to go through the PSI?
I did, Your Honor.
All right. So counsel, both of the attorneys are well aware, but I want to explain this to you as well, Mr. Dennis. My ordinary role in a sentencing hearing, my ordinary procedure is I allow everything to be said before I decide how to proceed. But this case is a different one than that. It's different for a lot of reasons, which you'll articulate. But the starting point and the ending point is going to be this. I'm not going to sentence you under Home Vehicle Training Act. I don't think it's appropriate. And I'm going to lay out for you and the attorneys why I believe that to be the case. And the reason why, even despite many different letters that have been written in very good support of you, all of those things ultimately don't convince me that that's the way I should do this job. The primary reason is a combination of factors, really starting with the nature of the offense. The nature of the offense is you stabbed another individual. And whether or not you may have or can, because I'm going to ultimately give you the opportunity to withdraw your plea, submit a claim of self-defense remains to be seen. But the fact of the matter is that this offense happened all the way back in 2020. When I considered the potential for a Cobb's evaluation, I was certainly aware of the fact that you were going to be seeking or maybe advancing a self-defense theory. I talked about that with the attorneys in chambers, and we made a record of it. I was aware of the fact that this case involved a stabbing, and I was aware of the fact that you would technically be eligible for HIDA, even if the prosecutor objected to it. But what I was not aware of is several of the details that came up in the PSI. And those details include the fact, which I was not aware of, that after this event was committed, and when you failed to appear at the district court level, you then absconded to various states for a period of over 5 years. That type of action, absconding after the commission of a felonious assault case, and for such a long period of time, is itself problematic, because those who don't pay attention to and follow court orders are generally not viewed by this court as capable of being sentenced under HIDA, which means I would have to trust and believe that you would successfully complete probation terms. I also recognize that letters of support that you have offered tend to cut against those concerns because they seem to suggest that you've been doing well since you've absconded. But other items within the PSI contradict that contradiction. And what I mean by that is, one time in California, you committed an offense of driving while license suspended while you were on bond and absconding from this court. You were convicted of that offense 2 years later in 2024. You were also charged in a separate state with a separate offense of operating while intoxicated in Florida, but that charge was ultimately dismissed. Those two things also enter my mind heavily in deciding whether or not HIDA is appropriate. And again, for all of those reasons, the circumstances of the offense, even despite the circumstances of you, which is prior to this offense state, you only had one prior operating while intoxicated, it's still not my view that felonious assault under these circumstances, and with you absconding for 5 years, committing 2 different criminal offenses over 2 different states, even if you weren't convicted of one, suggests to me that I should grant the discretionary role and offer HIDA as a sentence upward. And so I'm not intending to do that. That gives you the opportunity, Mr. Dennis, to decide whether or not you want to move forward with sentencing. If you move forward with sentencing, it would be on the felonious assault case, and it would be then just a typical sentencing hearing without HIDA. But you have an absolute right, because I gave this as a Cobb's evaluation, to withdraw your plea. If you withdraw your plea, then you have the option of doing whatever else you want through the combination of your attorney's suggestion and your determinations. You could set the matter for a trial. And if you set the matter for a trial, the jury is going to determine the issues. And ultimately, then I would impose punishment if and only if you're convicted of any offense. But that's your opportunity. My suggestion is that you should talk to your attorney about what you do and why. I should give you a break to do that. Mr. Seeger, I recognize that you may also want some time. Is that fair for me to expect? You want some time to talk to Mr. Dennis, or have you already?
No, if I could just have a brief moment, now understanding what the court may do or is not inclined to do. You can decide how it wishes to proceed.
Sure, and that's fine. Mr. Dennis, take a moment, talk with your attorney. It's an important step, and it's one that is entirely up to you whether or not to go forward with the sentencing or not.
So he absconded and he threw away his opportunity to have this felony, this violent felony, stricken from his record.
Again, to be clear though, you have an absolute right to withdraw your plea because I'm not going to grant you the height of status that I provisionally told you I would. So take a moment, talk with your attorney, and then let me know how you want to proceed.
Thank you.
All right, are you ready to recall the Dennis matter, Mr. Seeger?
I can be here.
Let's bring Mr. Dennis back in then. And we're going to retrieve Mr. Dennis. We are back on the record in People versus Wesley Jason Dennis. Mr. Seeger, did that break give you enough time to talk to Mr. Dennis?
It did, Your Honor. For the record, we had previously discussed the matter, not knowing specifically how the court was going to do things in advance of today's date. So this is my confirmation of things.
Sure, and that's understandable. I'll certainly cover that with Mr. Dennis, and then ultimately hear from you, Mr. Seeger. All right, Mr. Dennis, I've recalled the case. I confirmed with your attorney that he had enough time to talk with you, but do you agree that you had enough time to talk to him about how you want to proceed?
Yes, I did, Your Honor.
All right, Mr. Seeger, how should we be proceeding then? Does your client wish to withdraw the plea?
He does not, Your Honor. And I did explain to him that he did have the opportunity to withdraw his plea if he wished. However, it's my understanding that he wished to proceed forward.
Is that accurate, Mr. Dennis?
Yes, Your Honor.
All right, any problem with that from the prosecution side?
No, Your Honor.
Then I'll start with just a repeat of the same question I already asked. Did you want to look back in the courtroom, make sure whether or not there's any victim that wanted to allocute?
Your Honor, Mr. Wiggins had informed me that he was not going to be present today. He had work.
Okay. Then I had received several different items. I think the attorneys received them, but I want to make sure because I've considered all of those letters. I've already referenced them. And that was a letter from a Matthew Money, a letter from a Bonnie Rich, and a letter from the grandmother Barb. I can't really read the last name, but I read the letter from the grandmother as well. Did each of the attorneys receive those letters?
I did.
Yes, sir.
Any objection to the court considering them?
No, Your Honor.
No, sir.
All right, then on behalf of the people, your allocution, please.
Your Honor, it's a very unique case. The defendant is 19 years old at the time of the defense, but he stands before you now as a 25-year-old. He appeared in court in 2020 when the offense occurred, but apparently absconded to California and Florida for several years in between. The court has already addressed in its consideration of HIDA much of what I can say about Mr. Dennis. I don't wish to retread that ground. I think the fact that he had absconded for a period of time, the fact that he had left the state, the fact that this is a severe offense, all militate against HIDA and all support the recommendation contained in the PSI. So I support the recommendations of the author, Your Honor. I think a term of jail followed by probation is probably the best way to address the sentencing goals of punishment, deterrence, and rehabilitation. I don't think a straight probation sentence sends the right message to the community, especially in light of the defendant's actions both during and after the offense. I don't think a straight jail sentence addresses the youth of the defendant, his lack of significant criminal history, or his potential for rehabilitation. So I think a 6-month jail sentence followed by a 12-month probationary term is a fair compromise in this case, Your Honor. It's low to middle on the guidelines, and it fairly balances the defendant's moral conduct in the offense and on bond with his potential going forward. So that's what I would ask the court to do.
Thank you. Mr. Seeger on behalf of Mr. Dennis.
Mr. Dennis is a young person who does not have an extensive criminal history, albeit I know that the court had noted there were some out-of-state smaller, I'm not sure how they're characterized in other states, Your Honor, but One was dismissed, the other was a driving while license suspended, at least by Michigan standards, driving while license suspended would not be a serious offense, or at least I would not. Statutorily, it's not a serious offense. I don't know how it's characterized in California. Be that as it may, and I don't necessarily disagree that some of his conduct was not appropriate, especially given that, he was charged with the crime and then he absconded for a period of time. But young people make young people decisions. He had indicated that he had worked there, he had opportunity there, and he took the opportunity to try and better himself. And in as much as that was the wrong decision, that's what he elected to do. And so he accepts responsibility for that. But be that as it may, Your Honor, because he is a young person, because the court unfortunately is not giving him the benefit of HIDA, I think that if the court is going to place him on probation, he's already served 76 days in jail, which perhaps in our profession is not an extensive period of time, but I think it is a corrective period of time where people can stop and reflect on what they've done. And I think that's what Mr. Dennis has attempted to do. He could have withdrawn his plea, Your Honor. We could have pursued a different line of defense. We waived those things by virtue of entering into a plea, by not asking to withdraw our plea. He's being sentenced without the benefit of HIDA. At one point in time, the prosecuting attorney did not specifically endorse it, but did indicate that he would not oppose it. The court subsequently allowed us to file a COPS motion such that the court reviewed it. And it sounded like the court would have considered giving him the benefit of HIDA, but for perhaps the absconding portion and but for perhaps some other marginal criminal behavior in other states.
Yeah, those things matter. Shoulda, coulda, woulda. He had a Cobb's agreement. He doesn't have that anymore. He threw it away. And his actions have shown that he's not going to comply. That's not young people making young people decisions. He knew exactly what he was doing, and he chose to do it.
And had that not been the case, hopefully he would have received benefit of HIDA, but that's not the case. And so I guess he goes forward with sentencing without having that. But the guidelines are 0 to 17 months. The court does not have to impose any additional jail. He is a young person who is capable of rehabilitation. I don't disagree that picking up new charges in other places doesn't necessarily look favorably, but I would also mention that they're not felonies, or at least as far as I would believe them to be, they're not felonies. And one matter was outright dismissed for whatever reason. So to that end, Your Honor, he does indicate that he has work prospects available to him. He wants to try and put this behind him. He recognized that his actions were wrongful. He's remorseful for what had happened. But again, Your Honor, I can't express enough that he is a young person who probably made young person decisions, including the underlying offense in and of itself. And to that end, Your Honor, I'm just asking the court to consider placing him on probation for a period of time, giving him credit for time served. If the court wishes to hold a period of jail in advance, I have no objection to that either. But I don't really see the benefit in giving him additional jail time, given that this is a 5-year-old act, albeit it is a 4-year felony. He's already served time in jail. If you're going to give him the benefit of probation, then he might as well start working on his probation and the things that he needs to work on through there. But if he had received HIDA, it's not that the court couldn't have given him jail. It's that ordinarily the jail or the court does not impose jail time when somebody is granted the benefit of HIDA. But in this instance, he's working in a different situation where conceivably he was going to receive it, but now is not receiving that benefit. So I think in many ways, Your Honor, that's I don't want to say it's a punishment, Your Honor, but it's something that the court has already contemplated in terms of fashioning the sentence. And so I would just ask the court to consider placing him on probation for a period of time, give him credit for the time that he served, and if the court thinks that additional jail is available or necessary, to hold that jail sentence in advance to give him the opportunity to pay his court costs and fines and start working through his probationary orders.
Thank you. Mr. Dennis, was there anything you wanted to tell me before you were sentenced today?
Yes, Your Honor. I wanted to say that I am very sorry and remorseful, and what happened got out of control, and there is different ways I could have handled it, and I can see that. being 5 years later and an older man and just trying to do good. And I want to continue to do good and put this all behind me.
Thank you, Mr. Dennis. Certainly, there's a difference, Mr. Dennis, in your makeup, your psychological makeup in between the time of this offense when you were 20 and now when you're 25. And so while generally that delay could obviously be held against you, it was held against you by me in terms of, I think it counteracts any good suggestion of HIDA. I also understand that you looking back at this offense over that time period, you probably have a lot different perspective, and you've probably grown a lot as an individual since you were a 20-year-old at a party with a knife. And I have read through the totality of the PSI, which does a good job, I think, of detailing all of the different views and perspectives of the case, which led to what I think your attorney now in context fairly brought up is a potential defense that you may have offered if you chose to have a trial. It's a muddied potential offense because there was claims that you lunged at the individual that was the victim even after stabbing him the first time. It's muddied because some individuals that were interviewed by police seemed to suggest that you were the person who started the event and could not then avail yourself of self-defense. But it's also muddied because at least one individual within the PSI seemed to suggest that you had somebody on top of you beating on you at the time that this happened. And certainly you at least advanced some version of that theory to police. Even though you didn't talk to them much, you advanced some theory of self-defense. So I understand all of that background better now in context. And I appreciate the legal distinction that your attorney offers, which is that by pleading guilty, you've given up the right to have that legal self-defense claim. And you've accepted punishment and have accepted the plea, even though I told you I'm not going to give you the benefit of HIDA. I think that is a good demonstration of your acceptance of responsibility, even outside of what you've just said here on the court record, which is that you apologize for your actions and you're an older individual with better understanding of different ways you could cope with these things now. So I accept all of that, and I think it's a credit to you. And obviously, as I already referenced, the character letters that I've read, I always read them in every case, and sometimes they're very convincing, sometimes they're not. In this case, they generally are pretty convincing. It sounds like outside of this very dangerous incident, you've generally been able to do pretty well for yourself. You had the DWLS in California, you had a drunk driving charge that was dismissed in Florida, and you absconded, but otherwise, you've generally done pretty well. And it seems pretty likely to me that in the future, you will be able to do well as well if you keep that mindset and stay away from what appears to be, at least to me, a somewhat concerning trend of alcohol use. It appears clear that there was alcohol use by everybody at the time of this party. Perhaps even though, even if you denied it, it was clearly a party that had alcohol use involved. You had the OUI prior to this case, you had an OUI charge, at least that was dismissed later in Florida. So if you can monitor those things and get those things under control, it's very likely you're going to do well into the future. I also note that punishment takes many different forms. Some of the punishments in this case, you probably would not have suffered if you would have been here throughout the proceedings and not had that 5-year absconding period, but you did, and so you do. Part of the fair response to that is Judge Boudet revoked your bond when you got back here finally, and that bond has remained revoked, so you've been in jail for 76 days. For a felonious assault offense where a knife was involved and a victim was stabbed, that's not always sufficient. But I also note that for a 25-year-old who was 20 when he committed the offense, 76 days of jail is probably not easy, and it's probably not been a short amount of time. And I take that into account seriously because part of my duty is to make sure that the punishment fits the crime and the background circumstances. And the punishment in this case is not just jail. Because I am denying HIDA, you're going to have a felony on your record. That has other consequences. And while it will be my hope that later, if the law allows and if you prove that you're entitled to it, that you may ultimately be able to get this felony offense set aside, that remains subject to a lot of things that you're going to have to do. Be successful on probation. Otherwise, pay fines and costs in full, not get in trouble anymore, lead a good, clean life. And if you do so, you may be able to avail yourself of that legislative determination and ultimately judicial determination. But I'm satisfied at this point, Mr. Dennis, that 76 days of jail is enough punishment unless and until you make decisions while you're on probation that compromise that number. And those things could be like committing new crimes or not reporting to probation or absconding from probation. All of those things will likely result in much more jail credit much more jail, excuse me. And my likelihood of following more along the lines of what the prosecutors articulated is significant jail. But again, given your age, even given the background, and because I'm denying HIDA, I don't view that enough, that any more is needed right now. So I will put you on probation for 1 year. You're gonna need to check in with probation before you, or as soon as you are released from jail to sign a probation order. You're subject to all of the terms and conditions of that order. Again, to the extent though I'm not granting HIDA, I'm going to order that you pay a $30 supervision fee for each month that you're on probation. You're to pay court costs of $325, attorney's fees of $350, a DNA testing fee of $60, and a $68 state cost. By state law, those fines, costs, and assessments are due today. If you don't pay them within 56 days of today's date, a 20% late fee gets added on.
I personally don't think it's enough. I know he's already served 76 days, but that's really only a month and a half. I don't think it's enough for the offense that he committed. No. A year of probation? No. Not for that.
And ultimately, you will have the opportunity to ask the Court of Appeals for leave to appeal if you want to. Your attorney can go over those rights with you. You'll sign the top copy to indicate that you got them, and the bottom 2 copies are yours if you wish to ask for leave to appeal. I hope that you take probation seriously, Mr. Dennis. I can guarantee you that I'm going to take it seriously as I'm monitoring you, and so will probation agents. So make sure you understand what you're allowed to do and what you're not.
Yes, sir.
Do you have any questions?
No, Your Honor, thank you.
Mr. Seeger, anything further?
I just need the appellate rights, yeah.
Do you have those? Mr. Ziegler, anything further? Nothing further. I'm sorry, the crime victim fee is also going to be assessed. That was $130. I missed that one. That will also be assessed.
I totally meant 2.5 months, but my brain broke.
The court is going to bring in the state prison system and Ms. LeBrecq. Welcome in the IBC Unit 6. Are you Jesse Allen Davis?
Yes, yes, sir.
All right, welcome. And Ms. LeBrecq, are you able to hear the court?
I am. Thank you, Your Honor, for allowing me to appear by Zoom.
Of course. So the court is on the record then and calls the matter of People of the State of Michigan versus Jesse Allen Davis. This is file number, let me make sure I have the right case number. I'm sorry. This is file number 21-4561FH.
Ryan Ziegler on behalf of the people, Your Honor.
Attorney Adam LeBrecq on behalf of defendant Jesse Allen Davis, who is appearing by video as well.
Thank you. So we're here today, as the attorneys are well aware, on a remand order from the Michigan Supreme Court. And more specifically, while the Michigan Supreme Court considered an application for leave to appeal from the Court of Appeals, who confirmed my sentencing order and the convictions of Mr. Davis, they also, under their authority, in lieu of granting leave to appeal, remanded the case to the Kalkaska County Circuit Court to, quote, consider the defendant's argument raised for the first time in this court that he's entitled to 748 days of credit for time served. In all other respects, leave to appeal is denied because we're not persuaded that the remaining questions presented should be reviewed by this court. So the court is, of course, aware of all of that background. I'm aware of the specific background related to the sentencing credit issue for all of the reasons I'll explain. I have a lot of background knowledge with this case. I presided over the trial court proceedings with Mr. Davis, 2 different jury trials. And I'm aware of all of the different nature of the charges that were existing, the fact that he was on parole, the fact that the detainer was at once in place and then was subsequently lifted. In other words, I'm very familiar with all of that background. I also have benefits to me in this case, which is 2 different documents, one filed by each party after the remand order. And that was by the people, a filed memorandum of law, and by the defendant, a titled sentencing memorandum. So because I have all of that information, I'm going to dispense with oral argument, even to the extent this was a motion filed by a party. It's not. It's a remand order from the Supreme Court. The court understands its discretion that I can limit or dispense with oral argument. And because of the background record that I have in my mind and the records that's been created in writing by the defense attorney and the prosecutor, I'm going to dispense with any additional oral argument.
Your
the
Honor,
first thing the court will start with, Ms. LeBrecq.
I have one short thing that I wanted to address that I don't think appears correctly in either mine or the prosecutor's brief. And
go ahead.
Basically what it is he had a case which was a home invasion case, and it appears on the register of action with regarding bond. And I want to make sure your honor is aware of it, because that may be an underlying issue, and I don't want this to get bounced back one more time. The case number for the district court is 2025090FY. And the actual district court case number was 21-4590. It actually went to trial. He was found not guilty on 10/12/22. And I think I mentioned it, but what I don't think I addressed in my brief, and I think there was some confusion on the prosecutor's part, that there was a PR bond awarded to him on that case on 1/20/22. However, 2 days later, it's reinstated on 1/22/21, a review hearing where the bond was increased back up from 250,000 PR bond to 250,000 cash surety. So I just wanted to make sure that fact was put into the record. And with that, I have nothing else further to add.
Thank you. Anything else in light of that, Mr. Ziegler, then?
I guess, Your Honor, if that is the case, then the only thing that I would change in my brief would be that he may be entitled to 2 additional days credit if the court accepts my second line of argument about consecutive sentencing. But I don't think that would affect anything else.
All right, thank you. And the court notes that information, and it's been placed on the record now for purpose of further appellate review if and when it's ever needed. The court would also indicate that I agree in part with the Supreme Court, and I have no basis to disagree, and that's with remand order, because remand order was and is clear. They're remanding it to me to consider the defendant's argument. The point that I disagree with, and it's fairly clear why I would disagree with it, is the Michigan Supreme Court's indication and specific language that the issue of the defendant's jail credit was raised for the first time in the Supreme Court. That's demonstrably not accurate. It may be the case that the Michigan Supreme Court was not aware of all of the trial court proceedings. And I would understand that if and when this was the case, it does not appear that in the direct appeal that Mr. Davis raised the issue of jail credit. And therefore, when the Supreme Court is considering only what was raised in the direct appeal in the application for leave to appeal, it may be how the Michigan Supreme Court missed the fact that the court was presented with argument, legal writing and briefing by the defense, legal writing and briefing by the prosecutor, and oral argument the day of sentencing regarding this exact issue. So again, where I would just simply articulate a different point of view, the issue of jail credit is not in any way raised for the first time in the Michigan Supreme Court. It was raised. It was considered by me in advance of the sentencing hearing. It was argued at the sentencing hearing, and it was ruled upon me at the sentencing hearing. All which took place in the sentencing transcripts and are available to the parties to the extent you ever need it. The specificity of those sentencing transcripts was the court covered the issue of jail credit at between pages of 18 and 22 of the sentencing transcript. That was the court's findings as to the question of legal credit. But the court also invited the counsel to argue, and then in my sentencing discretion, in my sentencing of Mr. Davis itself, I also addressed the issue of equitable credit. That is, whether or not, even if I can't provide technical legal credit, whether I should provide equitable credit because of the many delays. And I went painstakingly through each one of the delays that were clearly in the register of action and who was the source of them and what was the reasoning behind it. And that was at pages 40 through 44 of the sentencing transcript. Again, I considered legal credit as well as equitable credit. I considered the arguments and writing the arguments at the sentencing hearing, and I made my findings as clearly and plainly as I could have. So when I look at the remand order, it's limited. The remand is for the Kalkaska County Circuit Court, me, to consider the defendant's argument regarding credit.
So this guy was sentenced. He appealed it. It went to the Supreme Court. The Supreme Court denied that he didn't get the proper credit, but sent it back to Judge Hunter for review, for Judge Hunter to determine if he was given appropriate credit or not. And the judge is like, I've already done this once. I'm not changing this.
I have considered it. I did consider it at sentencing. I issued the reasons for my ruling in as much depth and breadth as I could. And I've even reconsidered it today. And I know a couple of things. at any point, the court is free to reconsider any decision it's previously made, with or without a finding of good cause, with or without a finding of any prior error. I always maintain that ability. And here, this isn't a court-raised ability to reconsider. I've reconsidered because the remand order required me to consider the argument. I've considered it, and I rely upon everything that I said during the sentencing hearing and everything that was argued by the prosecutor, by the defense attorney, and my responses to those things, again, at pages 18 to 22 of the sentencing transcript and 40 to 44. Again, this is not an issue that somehow got bypassed, was not detailed by me, was not responded by me to the defendant's concerns regarding jail credit at the time of the original sentencing. It apparently was not known by the Michigan Supreme Court. I'd also note that there's a couple of different things that I think are worth covering in terms of the background. The prosecutor, for example, raises the issue of collateral estoppel. I think that makes a lot of legal sense. This has been decided already. But I disagree ultimately, and that's why I've explained already that I have reconsidered my prior decision. I'm not simply relying on that prior decision. I've also reconsidered in light of the arguments of the attorneys. But ultimately, I'm unpersuaded that there's any basis, legal or equitable, for the award of additional credit by defendant. But it absolutely makes sense to me that the prosecutor raised collateral estoppel as an issue, because this case has been already addressed by the court, by the attorneys, the same parties, the same court, the same arguments, and we're addressing it again now. So I understand.
I don't know what he's saying there. I know I do have some people with legal background that watch the channel. If you could educate me on collateral estoppel, whatever he's saying, I would really appreciate that.
Understand why the prosecutor would rely upon that. I do not agree that it's appropriate to title this, however, a sentencing memorandum by the defense. I recognize your argument, Ms. Lebrecht, and your argument is combined that I should reconsider or consider jail credit, or that I could consider this an invalid sentence. But it's not an invalid sentence. It was not an invalid sentence. It was not argued to be an invalid sentence by the defense following the sentence and the imposition. And even if it were, the Michigan Court of Appeals flatly rejected any such claim. They affirmed the conviction and the sentence. So did the Michigan Supreme Court, except to direct me to reconsider or to consider the issue of jail credit. So phrasing, although I understand why you would do it, the case as one of an invalid sentence is not found persuasive to me. And it's also not persuasive to title this a sentencing memorandum. This is not a resentencing hearing. The Michigan Supreme Court certainly had the authority to, and will maintain the authority to in the future if they want, to find my sentence invalid and to remand it for a new sentencing hearing. And even if they determined that they wanted to, at the appellate court level or at the Michigan Supreme Court level, they could dictate what sentence credit is needed if they wish to revisit any of the Michigan Supreme Court cases that they previously have. They will always have that authority. But this is not a new sentencing hearing. This is an opportunity for me to consider what the Michigan Supreme Court erroneously thought was the first time it was raised in the Michigan Supreme Court, the issue of sentence credit. But other than those characterizations that the court offers, again, I don't find convincing any suggestion that I made a mistake previously or that my discretion should be exercised any differently upon this remand. I have reconsidered the issue of jail credit, and I don't find that Mr. Davis is properly or legally or equitably entitled to any additional jail credit. Mr. Ziegler, I need you to prepare an order that just says, for the reasons stated, the court has reconsidered the issue of jail credit, but has not found convincing any claim that additional credit should be applied. Can you prepare that?
Your Honor, if I may?
Yes, sir.
I do apologize.
If you have a question, I can seek to answer it. Ms. Lebrecht, did you have a question?
It was more in the way of apology for the titling of that memorandum. I just do the fact of not knowing what to word it as, because it's such an odd situation. The Michigan Supreme Court did not put any case law, any rule behind it. They just remanded it. Probably would have been better reworded as remand memorandum. I just didn't know what to label it as. You know what I mean? It was one of those weird things. They did not put a case, they put nothing on it. So it was kind of, I had nothing to go on as to what to call it.
I totally get it. It is a confounding case when a higher court seems to not be aware of the diligence of trial counsel, of the trial prosecutor, and of the trial court, and when they don't provide any more reasoning. So I understand why it's titled a sentencing memorandum. I'm not attempting to poke fun at you for that, But I think in light of your suggestion that it's an invalid sentence and the fact that the Michigan Supreme Court could have said that but didn't, I think some articulation of at least my reasoning is necessary. So I don't mind
Oh,
the
absolutely.
title of it, other than to the extent I think I need to make a record regarding it. Mr. Ziegler, did you have anything else for today?
No, Your Honor.
All right. I thank you, counsel, for your detailed briefing. That is helpful to me, even though ultimately I've not been convinced. Thank you.
Thank you, Your Honor.
Court is in recess on this matter.
Good morning, court is back on the record. We call the matter of Sabra Smith versus Miguel Morales, file number 13-15007DS. Do we have anyone present on that?
I am here, Your Honor. Saber
Thank
Smith.
you. Mr. Morales, are you present?
Yes, I'm present, Your Honor.
Thank you. In front of the court, what is the status of this?
The defendant has a monthly obligation of $252 and the current balance of $1,471.67. Last payment received was in June of 2025 in the amount of $280.92. I have been in contact with Mr. Morales and he has advised he has lost his job and has been having difficulty finding a new job due to living in a small town and not being able to drive.
Thank you. Mr. Morales, what would you like to say?
I don't really have a whole lot to say other than, yeah, I've been laid off back in February, and it's been an uphill battle trying to get work since then.
All right. So you're laid off. Do you anticipate going back to work?
I'm sorry, what was that?
You said you were laid off. So are you going back to work?
I've been looking for new work. I'm not going back to that old company. I've been looking for new work, but I've since then lost my license too, and that's made it really hard finding new work within my transportation range.
When did you last work?
When I got laid off in February.
It might make it difficult, but not impossible. We've seen cases where defendants have biked 13 miles to get to and from their job. You just are lacking the determination and the will to get it done.
And you've indicated you've not had any income then since that time?
I had unemployment for a few months after that, but after unemployment ran out, no, I haven't had any sort of income since then.
All right. How are you making ends meet currently?
I'm currently by the skin of my teeth, really. I'm lucky enough that my girlfriend has a full-time job and she can pay, most of our bills, like our rent and such. I've kind of just been, I take care of the house.
Well, what's your plan here moving forward?
I'm not entirely sure. I'm still looking for work. I don't want to not be working. That's obviously never the goal. I don't really enjoy being stuck at the house all the time. But like I said, I've just been having troubles. I'm hoping maybe I can get a job at my girlfriend's place of work. I've worked there before, but they haven't had any new openings as of right now. So I'm still waiting to see on that, but that'd hopefully be something that could work. It's just being able to get to a job right now that's really getting me. It's like I live in town, Boyne City, but there's really not a lot of opportunities that I can walk to, especially upcoming, with the weather going into winter here soon.
When did you have your last job interview?
I haven't had any interviews since.
Okay. Ms. Smith, anything that you'd like to say or any questions that you have?
I'm sorry, what was that, sir?
Any questions that you have or anything that you'd like to say?
I guess my only question is, if you're sitting at home all the time without a job, why haven't you seen your son in over a year?
Well, I'm only here on support, so I'm not gonna, you don't need to answer that, sir. So anything you want to say regarding the support matter, ma'am?
I don't understand. That's all with that. Yeah, the whole thing. I understand what the court thing is saying. I understand what you're saying. I just don't understand his side.
Okay. All right. I'm going to adjourn the matter and set it before the judge for a contempt hearing. What we heard is that there hasn't been work since February. We've now had 8 months pass without any employment. Apparently no interviews. So I don't see much effort or motivation going on to seek jobs, just rather indicating it's hard to do because of the lack of a license.
I've put my share of applications out. I don't get very much back from them. I've called a few of these different shops I've applied to, and they've all told me I don't have enough experience to work for them.
But I think there has to be a better effort. I don't think you can just sit back on your laurels, let this thing continue to get higher and higher while you don't have any income to make a payment. Obviously, it can be difficult without a license, but that also doesn't mean you get to get off the hook of paying support. Sounds like Ms. Smith has this child the majority of the time, so there certainly is an obligation to get payments in. So as indicated, I'm adjourning the matter for a contempt hearing before Judge Hesselink on, looks like December 12th would be the date he is available in December. So you'll get notice, both parties will get notice for that hearing. I will set a purge payment in the event that you are able to come up with some money. If you are able to pay $850 prior to that date with the judge, then the matter would be removed from the docket and we'd continue to monitor moving forward. All right, thank you both for appearing. You'll get notice for that hearing. You're all set for today.
Thank you, Your Honor. Have a good day.
Next calls the matter of Shannon Sousey versus Kayla Stantz, file number 23-19380DM. If anyone present on that matter. Does not appear that either party is present. In front of the court, what is the status of this file?
The defendant has a monthly obligation of $48, and this case was recently adjourned from August 13th to monitor her payments. The last payment received was in August in the amount of $50. Current balance is $747. I did speak with her yesterday after noticing that she had updated her address to somewhere out of state, and I wanted to make sure that she had everything ready for court. She confirmed that she did have it and that she would be present today, so I'm honestly surprised she's not here.
She only owes $48 per month. Yup. Yeah. And she's behind, what was it, $750? That's a lot of months missed. At only $48 a month.
Any thoughts on bench warrant versus adjournment?
I think a bench warrant might be appropriate. She did tell me that she is back in Michigan, but I do not have a good address for her at this time.
All right, given the lack of payments and appearing today, I do think a bench warrant is appropriate. Recommend a bench warrant amount of $500 plus $100 in cost.
Your Honor, I had
Yes.
Kayla Stantz appear in the waiting room about 2 minutes ago, and I have brought her in, so I'm not sure if you want to recall that case or that. And then also the gentleman on the Motorola, if you could unmute and let us know who you are.
All right, so he's still muted. I'm going to move on to Ms. Stantz. So I'll recall the matter of Shannon Sousey versus Kayla Stantz. File number 23-193. Good morning, Ms. Stantz.
Good morning.
I called your case. You were present, so I recommended a bench warrant. Can you indicate why you are tardy to court?
My paperwork and the paperwork that Shannon has says that court was at 10 o'clock.
All right, we'll take a look at that.
Because I'm back in Michigan at Shannon's house, so I verified on his paperwork, and it says 10 a.m.
And the judge says, prove it.
All right, well, are you able to bring that in then to the court so we can see that?
I have a notice that was sent indicating the show cause is adjourned to November 5th at 9:30. That's in the court file, so if there's other paperwork going out with the wrong time, then I want to make sure that that is corrected. So can you bring that document to the court?
I can.
All right. And you're verifying to me that you have a piece of paper that says your court at 10 o'clock.
That's what the paperwork says on Shannon's paperwork.
All right. What does your paperwork say? You didn't get any?
I did not receive it because it went to my mom's house and I ended up moving back to Michigan and I'm at Shannon's at the moment.
Can you indicate why you are tardy to court?
My paperwork and the paperwork that Shannon has says that court was at 10 o'clock.
All right. So for that paperwork, did Shannon tell you the date and time, or did you actually look at the paperwork?
Shannon told me the date and time and he verified this morning that it was at 10 o'clock.
All right.
Before he left for work.
All right, so we'll have you bring that in, and then in front of the court, you can run through the background of this case again, since we have Ms. Stantz now present.
So this matter was adjourned from August 13th to monitor the defendant's payments. Her monthly support obligation is $48 and current balance is $747. The last payment received was in August in the amount of $50.
All right, Ms. Stantz, so what is the update?
I just made another payment yesterday. I'm not working. My husband is working. I'm trying to work on getting my driver's license back so I can obtain a better job, but I did just make another $50 payment yesterday and I will continue to keep making them to try to catch up.
Okay.
And with taxes, I will have everything caught up by the when I get my taxes in the beginning of next year.
Are you willing to share your address right now so it can be updated, or would you rather call the caseworker and provide that?
Right now, I just have my mailing address is Trillium Trail, Gaylord, Michigan. It's the same as Shannon's.
Okay, so I will have front of the court update that. Obviously, if and when that changes, make sure you let your caseworker know. I'm going to adjourn your matter out just to make sure that that payment went through, because I don't think it's been processed yet by the court. I'll adjourn to January 14th so we can make sure that you make that payment as well as then your December payment. Any questions, ma'am?
No, sir.
All right, and I also need you to bring that document in because we need to see what the error is in the paperwork.
Okay.
All right, thank you.
Thank you.
How much you want to bet she doesn't take the paperwork in? I'm calling that one. Her version of the paperwork doesn't exist. Judge confirmed it. Because it gives you a short-lived sense of euphoria. It's a chemical that messes with your brain. And it releases all the dopamine. And then it ends and they need more. Yeah. Yep. Someone that I knew that has a pretty severe addiction to it, they would say the bubble. They were on the bubble. Cleaning products, gasoline, cold medicine, you name it. Yeah. Just, I mean, you can Google what's in it. And the thing is you never exactly know what's in it because it's not like they follow a recipe. It's made in some shifty dude's bathtub. It's not good. Yeah, it's a direct request for death. Yep. Yeah. I saw a body cam video where there was a woman actively doing that as the cop walked up, and she locked the doors and just kept multiple times as the cop's standing there trying to break the window. And then she started the car and started driving. Crashed it in a parking lot. It was wild. All right, guys. I'm gonna call it a night. It's after 1 a.m. Yeah. Yeah, that was crazy. I would show it, but it would demonetize the whole stream. That's one that if I'm going to show it, I'm going to do it on a night when I'm going to show other similar content. If I do it now, then YouTube takes everything I've already done. And that was good stuff. I don't want to take them to take my monetization out of that stuff. The Walker trial at 9 a.m. I am going to try. I'm going to try. Well, but here's the thing. It's going to need to be edited. It's a trial. There's going to be lots of long delays. So what I'll do is I will get the download going for it. As soon as it's done, then I will edit it quickly and we'll see. Maybe, I mean, it depends on how long it is, but maybe I can do an early afternoon or late morning stream. But I know how desperately you want to see that one. But I have to edit it so that we're not just sitting and waiting for the defendant to get their paperwork together or whatever the deal may be. So you say that like it's an advertisement. I remember when they pulled the cold medicine off the shelves because of meth heads. So I'm a little salty about that. Methany took my cold medicines away from me. Now I have to show ID to get them. And you're only allowed X amount per month. So when I was having to buy cold medicine for a house of 5 people who were all sick at the same time, and I was the only one that would venture out into the world and you know, contaminate everybody else, but it was long before 2020. So at that time that was a normal thing. You know, you wash your hands and out the door you go and you know, just cough into your elbow and try not to cough on anyone and but yeah, I went out to get cold medicine and I actually got denied. I was told that I was trying to buy too much of it. I'm like, what? And they're like, well, you can get this box, but you'd have to select a different type if you wanted a second box of it. And so then I had to go onto the shelves and I'm like, and they're like, oh, well, if you don't get the extended release, you can get one that's the you know, instant acting, but not extended release. And then the numbers, you know, you're only allowed X amount of grams per month. And it was ridiculous. Like, have to sit there and math out my cold medicine for 5 people. Hey man, I have all my teeth. They're coffee stained and I've got metal fillings, or amalgam fillings, but they're there. Oh my goodness. I know with spray paint and the glues, oh my gosh. It's almost getting to a point where like you got to show ID for almost everything, and it's a database. They scan your ID and it keeps track of what you've bought of those products, but it's because of so many Methanies. Yeah, there's actually just a documentary out about that not too long ago, where they were talking about how it can be prescribed. I know someone who is prescribed it. So, oh man. And then when they added the bitters to it, oh, that ticked off a lot of people. I have 4. I have 4 cats and a dog. 2 cats are indoor outdoor and 2 cats are indoor only. Oh, I love you, sweetie. Hello, Sandy Hurd. Oh, I'm so sorry. I hope we smiled and laughed and brought your spirits up a little bit. And I hope you feel better. Maybe a good night's rest will help. Not exactly. Oh, yes, yes. It's more like the cats run the house. You are just so anxious. I've got the door shut. Earl can't get in here. Not unless Ava opens the door, which she knows how to do, but she's laying down. You're fine. Go get a drink. We do love you, Sandy Hurd. So as Charlie pointed out, there's an episode. I did an episode that I didn't live stream. I wasn't aesthetically appealing enough to live stream. I needed a shower and I just didn't have it in me to take it at that time. So, you guys should all go watch it. It's really good. It is really, really good. Yes. It is Judge Hunter. And he's taking care of a child support case. Baby, just relax. Hello, Shane. Good to see you, sweetie. I thought that was basically just called Double Jeopardy. Thank you all for educating me. I needed it. I needed the education. Yes, the Judge Hunter. Jeopardy is criminal liability? Oh. I thought Jeopardy meant that you just couldn't be tried for something twice. I have a lot of learning to do. C-Rex, you are amazing. I'm so grateful to have you in my life. Estoppel is any other decision? I'm not gonna lie, guys, I don't fully understand. Jeopardy is giving the answer in the form of a question. Dang it, I was reading that like you were serious. Oh man. I was reading that like I was seriously gonna learn something in that sentence. I should know better. Yeah, you did. You did. Oh, you won that round, Mortimer Duke. Okay, guys, on that note. Oh, I love you all so much. Be safe, be well, sleep sweet, and much love.